I am doing. It is crazy. I am the first person, the very first person to do what I'm doing. Um, and all I'm doing is enforcing our civil rights. So if you guys are wondering how I can put someone in jail over a Facebook block, I'm going to explain it to you. So, a district attorney named Michael Obel of Fayette County, Pennsylvania. If you Google him or me, you will pull up a bunch of garbage. Uh, has decided that he would block me on Facebook after disclosing the fact that he knew it would be illegal to do so. Now, under Pennsylvania law, there is a law called well, I forget what it's called, but it is Title 16 PACS section third or no 14301 305. Yeah, 16 PACS section 14305B. And what this law allows you to do is file a complaint against the district attorney alleging willful misconduct or gross negligence in the performance of their duties. Now, running a Facebook page is a function, a discretionary function, which he is able to violate civil rights in a discretionary function, and it still applies as a crime under a PA official oppression, Title 18, 5301. So, blocking someone on Facebook is under the Linkey v. Freed ruling from 2024, an act of official, well, it's not official oppression, it's a state action, which implies state action doctrine protection. And what those protections are is due process. So before you can be blocked on Facebook, the Supreme Court has ruled that you are entitled to your due process rights and that it is a personal liberty interest to be able to participate in a public forum, such as an open public forum on a district attorney's Facebook page when he allows commenting. So that being said, what this guy has done is blocked me, therefore taking state action against me. Now, there's a ruling out of Pennsylvania, Markey versus Yardley Borough, and anyone can look that up. And what that says is that as of October 2022, it is illegal, or it is clearly established that it would be illegal or a violation of a citizen's rights to block them on social media. So what I've done is tied all these cases together, proven that this district attorney violated my civil rights. And what was funny is he was so confident that he could get away with anything. And what this idiot did was I created an alternate account because I was commenting and I'd mentioned to a buddy, oh, I commented this. He tried to find my comment and wouldn't be there. So I'm like, okay, that's a little weird. So I created an alternate account. And with this alternate account, I went and I interacted with this DA's page and acted like I was a supporter. I'm like, good job, man. Good job. And, he'd like those comments. And then I messaged him one day. He's getting a lot of heat over a case that was in the news. And I was like, I can't believe all those people are saying those nasty things about you. I like you. I support you. You're a good man in my book. And he's like, oh, thank you. Thank you so much. Oh, it means so much. I hate it when they say that stuff. Blah, blah, blah. And then waited a couple days, said some other bullshit to him just to make him think I was a supporter. And then I decided to mention that he should block me in my Facebook news page from his account. And in response to that, he said, it's not legal to block him, but I can hide his account comments, which one, he cannot hide my comments. In the case of Markey versus Yardley Borough, they had one comment. He got $2,500 in a federal lawsuit that he filed. So there you go. If they delete your comment or hide it in PA, at least in the 3rd district, which I think that incorporates it's like New Jersey and some other areas, but in that federal district, it's at least $2,500 a comment if they block your comments or hide your comments or censor you on social media. I mean, you see all these First Amendment auditors out in the streets with their cameras and stuff getting in people's faces and annoying government workers while they're, out in public. I mean, First Amendment applies to social media. Why don't we test it there? The courts are already much more favorable to a Facebook comment than they are to a guy, sticking his camera in people's faces. I'm not taking sides on the First Amendment auditors issue. I know some people like them, some don't. But I mean, First Amendment applies to a lot more than just a camera and just being in public. But nonetheless, so, I got this guy basically dead to rights because he admitted it would not be legal. And how that really helps is Pennsylvania's official oppression statute, 5301, and it requires a knowledge that it would be illegal and that they would be violating your civil rights. This guy admitting that he knew it would be illegal to block me and then proceeding to block me proves he meets all the elements. He did it, he violated my rights, and he knew it would be illegal to do what he was doing and that it would be a violation of my rights. He admitted all of that. So we have him dead to rights. Yesterday, his attorney filed their brief. And what's funny is I filed my brief. I can't talk about what happened with my brief because there's a gag order. So there's some crazy stuff. One day I wish to be able to talk about it, at least share my side. There is stuff out there in the media about me that I would just say what I see in the media is not true. I'll just say that. I can't say anything else beyond what's been, because there's a gag order. That's all I can say is there's a gag order over me filing my brief. But nonetheless, it's not from the Commonwealth Court who I filed my brief from either. Anyway, I filed my brief on December 3rd. The DA's attorney, Marie Millie Jones is her name, out of Pittsburgh. You can look her up. She decided to take this case and defend him violating civil rights. And she requested an extension. I had 40 days. I got mine in about 6 days early. So I filed my brief early. She requested an extension, claiming that she never received my brief, but I sent it certified mail, and I talked to the post office, and they're like, yeah, we would not give that out to someone that is not that person. So they got the brief. 4 days later, they decided to return the brief and write return to sender address unknown on it, despite every other piece of mail being sent to that address being received in, that being the address of record with the court. And I even confirmed it before I sent it, because it costs money to package that and send it out. I don't want to waste any money. But nonetheless, she decided she didn't receive it. So she's like, oh, I need an extension. So they gave her a 15-day extension that expired yesterday. She got her brief in, and it is hilarious because I'm pursuing a 14305B petition, a complaint alleging willful misconduct and gross negligence. And these allegations are based and centered around an act of official oppression, which is centered on violating a known right. So did he knowingly violate my civil rights? Yes. He admitted he knew it would be illegal to block me, then he blocked me. So with that being said, she decided to say, oh, well, no, these are civil rights claims. They have to be filed in the federal court. So it's outside of the Commonwealth's scope to consider civil rights claims. No, it's not. The entire case centers on whether or not my civil rights were knowingly violated by this man. They were. So with that being said, this 14305B petition just needs probable cause to go forward. Probable cause is a very, very low standard. I've established probable cause. I submitted his statement, and then I submitted documentation of my accounts being blocked. I submitted his right to know request or denial, because in Pennsylvania, it's called the right to know request or right to know law. You guys know it more nationally as the FOIA, Freedom of Information Act. I filed a request for a block list and several other things from this DA's Facebook page and his usage, because he's definitely violating my civil rights on there. So in regards to that, he responds denying me, and he writes a letter saying that I should be denied access to public records because of the content of my character and the fact that I cover negative stories on the government. I submitted that as well. That's a part of the record. That's part of my complaint against this guy. Now, if you guys know anything about the First Amendment, you're allowed to do negative stories on the government. If you know anything about freedom of information or right to know laws, those enable any citizen, any lawful citizen, which I am, of the United States, any citizen. You could be a child rapist, you could be a pedophile, you could be a terrorist, you could be a murderer, you could be a bank robber, any terrible crime. You can get public records. They cannot hold the content of your character against you or the fact that you're going to do a negative story on the government. If that were the case, they could just deny every journalist with the same claim. Oh, they're going to do a negative story on the government. This information will look bad on us, so we don't have to give it to you. What? That is Michael Anthony Auble of Fayette County. That's what he's done. I can upload all the documents. So if you guys really want to pay attention to a case, people keep telling me like, oh, you're like the next Turtle Boy. I don't know about that. I'm not involved in like uncovering a murder cover up by the police or anything like that. I'm uncovering retaliation by a district attorney. And the action I'm pursuing is the first action of any kind to have a public official held criminally liable for blocking someone on Facebook. I'm sorry, but it is what it is. That's how the law is. If you guys study the law, you can use this against them. You can use their own weapons against them. Fight fire with fire. The Supreme Court has said that in Linkey v. Freed, it was ruled on March 15, 2024. You can look it up. That it is state action if they block you on Facebook. What is state action? That's the important term that everyone overlooks. They're like, oh, it's your First Amendment. No, focus on what they're actually saying, what doctrines they're mentioning and invoking. They invoke state action doctrine, which means that you have a right to due process. We all know due process. You have a right to a hearing, claims against you, to defend yourself. You have the right to an attorney, all that before state action can be taken against you. So if someone is just arbitrarily banning people or blocking people or setting parameters that will block people and block citizens, that amounts to state action without due process of law. So that's a violation of your civil rights. Okay. So with that being said, he knew that. This district attorney admitted in a Facebook message to an account I made, a fake one that I made, just to trick him. And the idiot took the bait. So, I mean, you guys just put a little bit of thought in this. I'm a mechanic, dude, in a factory. I ain't some rocket scientist or anything. I just put 2 cents together and was like, hey, I bet I could get this motherfucker. It was easier than catching a squirrel outside. You know what I mean? The guy was not very smart, and I suspect from what I know about politics, that's going to be the case across a vast majority of municipalities. Is these people are not very smart that get into public office. They are just ass kissers and manipulators. They don't care about your civil rights. I don't think anyone that actually cares about the Constitution runs for office. I mean, seriously, from what I see, it's just a bunch of self-serving people. And if you talk to a lot of people that do work for the government, the reason they're like, oh, I got the job, it's great benefits. Okay, you got it because of benefits. What else? Oh, well, good vacation time and retirement. And it's like, never once will you get them to say, I mean, at least in the top 10 reasons that they began a job in public service for the public, that they wanted to serve the public. Very rarely, I would say, that is the case. Most people do it because they're self-serving. That is why you get a job. You do it because you're self-serving. You're entering into a contract to trade your time for money, for benefits of some kind. So these people aren't doing it because they're selfless. They're really not. So whenever you see these cases of them blocking people, and you see it all the time, like anytime like a police department goes viral, they immediately shut down comments. Why? Because they're sensitive little pansies that can't take criticism. So anyone out there that wants to do First Amendment auditing or like is into asserting your rights, I would say try it on social media. You have every right per the Supreme Court to go out and assert your rights on social media. Don't make no threats. Threats are, as established and defined in the Bradenburg v. Ohio case, is, is there an eminent lawless action that is threatened? And is it likely to occur? So I really think that what's going to happen is we're gonna see the case end in my favor, and then we're gonna see a bunch of other citizens hopefully pursue the route that I've taken and hold their public officials accountable. There is no defense to Mike Auble. You can look into it yourself. This case is hopefully ruled correctly by the PA Commonwealth Court. I think they will. They've ruled in citizens' favor before with this type of complaint and allegation. He has really weak defenses. Just trying to say it's the wrong venue. It's not. It's not. I'm not asking for damages. I'm asking for accountability, which is what the law allows. I'm also spot on. The judge puts in his order that he used the wrong statute. He denied my petition under A, and like the difference is like with 14305A complaint, that's like if a district attorney gets pulled over for a DUI or like murders his wife, and then the prosecutor or the state can take a complaint, make this complaint, file this petition under 14305A to have him removed. Or if like he gets caught in like a bribe scandal or something by the feds, they can file to have him removed. But it's from a position of authority for specifically defined reasons. 14305B is the mechanism for citizens, and that's the one I've pursued whenever he's taken an illegal action against me. I've got it plain as can be. So District Attorney Mike Auble is going to be the first district attorney, first public employee in the nation to be kicked out of office for violating our civil rights. I think more people should be willing to test their civil rights on Facebook. Let me know what you guys think. Is that something that you guys could get down with, is auditing government officials on social media? Has to be their official government page. Now in PA, there's a case, Pencrest School District v. Kregel, and in that case, they determined that if there's like trappings of an official account, so like if it literally says Fayette County District Attorney's Office, Mike Auble, District Attorney, or District Attorney Mike Auble, then you will be able to say that's official trappings. If the description, as his does, says government organization, and if the bio says the official account of the District Attorney Office of Fayette County, then you have them for at least in Pennsylvania clearly defined official account that is subjected to First Amendment right to know request, all that, because that's what Pencrest School District v. Kregel was a right to know request. So across all platforms in Pennsylvania, they've sided with the citizens, whether it was the state courts or the federal courts that oversee the civil rights aspect, or the right to know courts that oversee it. They side with citizens on this. So his attorney wants to say it's a 1983 lawsuit. I got one thing to say to that, Miss Millie Jones. Not yet. That one's coming. That one's going to include a whole lot more. But the current case is not a 1983 case. It is a criminal action taken, or a criminal complaint taken against your client. So you're arguing it in the sense of a federal case. It is not a federal case. It is a literal criminal complaint against your client that's in Commonwealth Court, and you've already filed your brief trying to defend a civil rights case. You've messed up. Whatever Fayette County paid you to defend that man was way too much, because you didn't do a very good job. Even ChatGPT points out, like, my brief for a pro se litigant was miles above yours. You're literally begging the court to ignore the judge's mischaracterization of my complaint, even though the literal title of my complaint has the correct statute, and even though the judge is quoted in the transcript as saying exactly that it was a 14305B. He said, I read your complaint as a 14305B complaint. Yes, Your Honor, that's what it is. And it incorporates 14306, because once probable cause is established, we want to move on to the next step. I'm not just asking for you to find probable cause that he violated my civil rights. I'm asking for you to take the proper steps. But the judge recognized it twice, and then in his opinion, once he realized I was wrong, because I had to file a 1925B statement of errors complained of. So once he realized I was right and going to win the appeal, he tried to backpedal and say under 14305A, I didn't establish probable cause, and that he was looking like I would, and he kept saying I had to establish probable cause the DA was charged or convicted in another court. And I'm like, no, the probable cause standard is whether there was a willful misconduct and gross negligence in the performance of the duty of his duties. And from there, a special prosecutor or a grand jury is convened to investigate the complaint and my allegations. And if there is, in fact, probable cause established at that level, they move on to the criminal proceedings. I am following the same route taken by Eugene Grimm of Greene County against Greene County District Attorney. I think his name was David Russo. Anyone can look that up. That guy got removed for official oppression, retaliating against a public official and all that. And that's exactly what I've alleged. In fact, I know I've alleged exactly that because I followed Gene Grimm's complaint, like the entire format. That's how I knew about it. I saw the article, reached out, got a copy of the complaint, then just inserted my information, my facts, instead of his. And the same crime is alleged, official oppression. So official oppression is a standard by which 14305B can be considered. But yeah, there are a lot of people out there who are having their civil rights violated. They don't even know. Social media is the next frontier for asserting your rights as an American citizen. And I think more people need to step up and pursue complaints against bad acting district attorneys, bad acting judges, municipalities, cities, police departments. It's pretty simple now. If you go to like ChatGPT, and you have to be careful, but you go to ChatGPT, you enter your situation, you're like, I need a motion, or I need to file a federal complaint. I need to do it as a pro se litigant. Can you help draft me a federal complaint, 1983 complaint? It will do it. Then you copy that, you take it to Grok or your another AI model, and you enter it in there, and he's like, research this, improve it, analyze the legal theory, research case laws and relevant statutes, and it'll do that. It'll spit out everything. And you take what it tells you and you copy that back to ChatGPT, and you're like, hey, Grok suggested this improvement, and this is what it thinks. Consider this, and it'll consider it. And then you have the AIs debate each other. And once you get a final product, you keep asking for an updated motion with all relevant and strengthening positions and legal theories and case law. And once you get all that, then you just freaking research it. Whatever it tells you, copy it. If that case doesn't exist, tell it, this case doesn't exist. Is a citation wrong, or are you just making stuff up? I've done this multiple times successfully. I can't get into the most recent wins. There's a gag order on that. But I mean, I can get into what I've gotten on my brief. So I was able to solidify the Linkey stuff. I was able to solidify Marquee. I didn't even know about that. ChatGPT is pulling cases up that get ruled on and then filed. As soon as they get filed, it can pull that case information up. I've literally pulled up multiple cases that were mentioned, like in my brief. The same day the judge denied that social media First Amendment rights exist, that same day, June 24th, a federal case came out and said that it was clearly established as of October 2022 that social media First Amendment protections existed. So I had to file my statement of errors complained of at the beginning of August. So within that little bit of time, it was able to pull that case up and correctly apply it. So if you guys learn how to use this ChatGPT stuff, you really don't ever need to hire an attorney for this kind of stuff anymore. It's that simple. It is that simple. In the case of Marquis v. Yardley Borough, That guy was able to represent himself, and they blocked one comment. He got $2,500. Yeah, it might seem like a lot, but when you consider, oh, it's just a couple chat GPT prompts, and you're doing maybe 3, 4 hours of research on what it spits out to ensure correctness, because you don't ever want to go with it blindly. But if you do the research on it, you could definitely cut out the middleman. And that's what lawyers are, and they charge way too much, or they've been living high on the hog for way too long. And it's getting to the point where we don't need them. And it's the white collar workers that are going to be replaced first. They kept saying, "Oh, they're going to have robots replacing you flipping burgers." I still see a bunch of low wage McDonald's workers, but I tell you what, less and less white collar workers, more and more office buildings are shutting down, not coming back because the work can be done by AI assistants and stuff. So lawyers are going to be, I say in the next 10 years, lawyers are going to be like a poverty job. Like, you're not going to make too much money unless you're like top tier defending corporate clients. Other than that, most regular day-to-day attorneys are going to be pretty useless as AI models get stronger. We've seen the video creation, we've seen, improvements in the research. They build entire apps now with a prompt. It's insane. Entire companies are going to be founded on AI prompts. So that's where we're headed. And if you think lawyers are going to be relevant at all, whenever these are just large language models that research things that we've uploaded and every case law is uploaded, I think within the next 10 years, we will be a failed society if we do not somehow implement AI into our court system to improve it. Because there's too many bad rulings by judges that get overturned. It's like, I bet AI could significantly reduce that. I don't know. What do you guys think? I really think AI could make better judges, better prosecutors, better juries, and better lawyers. I really think that. But let me know what you guys think. And I'm going to get off here, so give me a like. Before I get off, give me a thumbs up. Give me a subscribe if you can. Share the video. Leave a comment. Tell me what your thoughts are. All right, guys. Thanks for watching. Oh, shit. How do I end it? Oh.